today in this video, I'm going to talk about something that has come up in the hearing. And a lot of times these videos are prompted by, again, conversations that I have with potential clients, current clients, and hearings and cases that I'm involved with, either at the Court of Common Pleas or the Industrial Commission. And this issue had come up in the hearing, and it's come up in the past, and it's come up in the past with other claimants. And basically, there's a number of defenses that employers will put forth in denying a workers' comp claim. And so one of the scenarios that comes up every once in a while is this concept of, they put forth this defense of coincidental to employment, i.e., you got injured, but it just so happened that you were at work and you got injured, and that's the only relationship to work, and therefore the claim should be denied. So that's not a legitimate defense to disqualify a workers' comp claim. It's not something that an employer can use to disqualify a workers' comp claim. So there are things that disqualify a workers' comp claim, and I could go over those, and I've gone over those in other videos, and I might do like top 5 or top 10 things that come up that disqualify a workers' comp claim. But and what I mean disqualify is you have a work injury, or you have an injury at work, and because of this defense, your claim is not compensable, i.e., you're not allowed to participate in workers' comp funding, you're not allowed to get comp, and all these things. So this coincident employment defense comes up. It seems like it comes up, the common fact pattern is somebody's at work, they trip or fall, and they can't specifically identify how they tripped or fall, or whether they tripped or fall over something at work, on the ground, water on the ground, a box in the ground that they tripped over, but they have tripped, and they've sustained an injury, but they don't know exactly precisely how or why that happened. So so the employers will say, well, and what they'll bring up is they'll have an IME, and a lot of these IMEs, doctors, and when I say IME, it's an independent medical exam. There's varying levels of quality and I don't know, non-bias, I suppose, with these independent medical examiners. So there's some that are, you could say, they're pretty honest and credible, and if they see it one way, they won't look to see who's paying them to give their opinion. And I'm not saying that these independent medical examiners, are essentially bribed to give an opinion, but certainly, depending on who you go to, or who and that is being paid to give their opinion, they're certainly more biased to say one thing versus another. And this happens to defense independent medical examiners and also claimants medical examiners. You have bias on both sides, but I think it ultimately hurts the credibility of the medical examiner. So I don't think it's a good idea for them to do that, but it happens, and some of these folks make pretty good money doing these IMEs. So if they were to, if, like, for example, the employer were to come up and say, hey, do you think there's a work injury? And they would say, they would say, yeah, I do. And they would say that consistently, like, 70% of the time, they'd probably not get follow-up business from that employer, because, one of the reasons you get these IMEs is to get the claims denied. But going back to this coincidental employment, so common scenarios: you're walking at work, and then you trip and fall. You injure your back, your knee, your ankle, whatever, and you're not sure how explicitly you tripped or fall. And then so again, the employer says, hey, they can't identify what happened, there was no hazard in the workplace that caused the injury. Therefore, it's coincidental employment. Therefore, it's a non-compensable claim. And oh, by the way, the independent medical examiner examined this person, and he or she has comorbidity of, they're obese. So the person is fat, and because they're fat, their I guess the implication is their body part spontaneously failed, causing them to trip or fall, or deep in the distance past they had this, some kind of knee injury or ankle injury, and it just so happened that they were walking and it just gave out. So here's the deal with these things. One, when and this is what your attorney will have to argue on your behalf, is you don't, if the injury, if you tripped or fell, or if you fall and that fall is due to, you had a heart attack, or you have like a seizure disorder, or you had some kind of situation where you faint, and the fainting or the thing that causes you pass out is not due to exposure to like a toxic gas or something, that would be an idiopathic reason why you fell, and therefore that would be a non-compensable claim. So what you have to do, or what your attorney has to do, is they have to eliminate idiopathic reasons for your trip or fall. So once they eliminate those idiopathic reasons, fainting condition, the seizure condition, the heart attack, something that just made you fall due to your inherent something with your brain, your body, then they've eliminated idiopathic reasons, and the assumption is they fell because something at the job. You don't necessarily have to point out specifically what caused that fall or trip. So that's where that coincidental employment doesn't come in. Basically, you have to prove two things to have a compensable injury, and this is I've got some case law in front of me, so I'm looking at my computer screen. But first, it has to be, to have a compensable claim. The House Supreme Court says that it has to be in the course of. So there's two things: in the course of and arising out of the claimant's employment to be compensable. So course of prong refers to the time, place, and circumstances surrounding the injury. So where did you get hurt? Okay, I got hurt at work. What was the time? It was the time when I was logged in working. And then the circumstances surrounding the injury. What were you doing? Why was at work? During the time I was supposed to be working, clocked in, and I was, performing some task. I was walking this box from point A to point B. So in that instance, I would argue that in the course of employment prong is fulfilled. So then you go to the arising out of, and this pertains to the totality of the circumstances surrounding the injury. The proximity of the scene of the injury to the employer's premises, the control the employer exercises over the scene of the injury, and the benefit of the employer derives from the claimant's presence at the scene. So you can look at it as benefit, proximity, and control. Benefit, proximity, control. So really, in that arising out of prong is implicated mostly when the injury happens in these going and coming situations, when you're driving to work, or you're in the parking lot. Basically, you're not in the place where you work. So that's where the benefit, control, and proximity to the place of employment. Because if you're working in a warehouse, well, the employer owns the warehouse, so they control it, or they're renting the space, so they have control of it. The proximity between the scene of the injury and the employer's premises, well, it's absolutely 100%. Proximity is absolutely site zero. It's right there because I got injured at work. And the benefit of the employer, well, the employer benefits from you being at it's kind of silly in this situation, but they benefit from you being at the site of the job. So that prong is fulfilled. Okay. So as long as you have those two things, and then you don't have one of these other things that would disqualify you, then it should be a compensable claim. And there are some defenses to make it a non-compensable claim, and I can go over those, and I've gone over those in other videos. And I may just do, like I said, like a top 10 or top 5 things that will get your claim denied. But so here's some cases that where this coincident employment defense had come up and was rejected. So in the first case is a Supreme Court case from 1979. Is Zarnacki versus Jones and Laughlin Steel. Essentially, the claimant was lifting a drum, experienced pain in his low back, and the employer argued that the type of event was not unusual and it could happen anywhere. That one's easy. I mean, that's kind of that's an easy case because obviously he's doing the work injury. That happens about with all these lumbar springs and stuff that we deal with. Somebody's lifting something or doing something. So the Supreme Court rejected the defense because the injury occurred at work while the claimant was performing his job duties. Simple. This is a 4th District Court of Appeals case. So you have the Supreme Court and then you have the Court of Appeals. So Supreme Court, Court of Appeals, and then the Common Pleas Court. So you're below that. You're at the administrative level if you have a hearing. You have a hearing, and you go to the Court of Appeals, and then if there's an appeal of that decision, goes to the Court of Common Pleas. If that's appealed, it goes to the Court of Appeals, and if that's appealed, then it goes to the Supreme Court. So, claimant was descending a flight of stairs towards the locker room on the employer's premises to change in his work clothes when he experienced pain in his left knee. Claim was allowed because it was sustained in the course and rising out of employment. The courts explicitly reject the argument that the injury was coincidental employment and not due to any unusual circumstances or event. So he's going downstairs to his locker room, and then he experiences pain in his left knee. So there's not any kind of crazy thing. He didn't fall down the stairs. He didn't trip. He just experienced pain in his knee, and he's doing an action, and so that's a compensable claim. So he's at work, he's doing his work activities, or at least he's either changing out or he's getting ready to go, getting his gear for the day in the locker room. So they found compensable injury. The next one, this is Griffin versus Hydramatic. This is another Supreme Court case, 1988. Is when this one was decided. And this is kind of an overarching. So there's some of these are very specific, and some of these are almost, you could say these are rules and these are examples of the rules. So the Supreme Court case that I stated first is Arnacki. That's a like a circumstances, and then they have the rule that they apply. The next one where the guy's going on the steps, that's kind of an example. This one's kind of a general rule. So the Griffin versus Hydramatic, the case was Supreme Court held an injury sustained by an employee upon the premises of an employee arising during the course and scope of employment is compensable, pursuant to Revised Code 4123, irrespective of the presence or absence of a special hazard therein, which is distinctive in nature or quantitatively greater than the hazards encountered by the public at large. So, basically, it doesn't matter if the thing that you get hurt, if you get hurt at work, let's say you go home and you lift the box and you get hurt, and you go to work and you lift that same box and you get hurt. It doesn't matter. Obviously, the home injury, that's at home. It doesn't meet those in the course of rising up. But picking up the box at work, performing your work duties, that is a compensable thing, even though that's not different than probably the same weight and possibly dimensions of boxes you lift at home. So it's not any more crazy. It's not that the requirement is that you have to lift up, 500-pound deadlifts at work for it to be a compensable claim. As long as there's medical to support that you sustain whatever this lumbar sprain in this case probably, then it's a compensable claim. This next case is this Cummings versus Thriftway. This is the 1st District. Claimant was, and this one is interesting because this is a good one, and this is a good one in the sense that there's really nothing that happened specifically. Like, this guy didn't trip over something, he wasn't lifting something, there wasn't something on the ground, he wasn't stepping on something specifically. But claimant was on the knees on the employer's floor showing a coworker how to operate a machine. When he stood up, he experienced pain in his low back. The court explicitly rejected defense that the injury was purely personal and coincidental employment because the injury was sustained, again, in the course of and the rising out of the claimant's employment. So this guy, he's just bending on the floor and he stands up and he gets his knee injury. So coincidental employment didn't work in that case either. Okay, so there's another case. This is from 2003, White versus Autism. A similar situation. Claimant was kneeling down to inspect a taillight on a customer's car and experienced pain in his right knee when he stood up. The court rejected the defense that the injury was idiopathic, but it could have occurred anytime, anywhere, because the injury was sustained in the course of and rising out of claimant's employment. So one thing I think is unique about this is because I think an employer could argue, and I think you could look at it and be like, well, the person just stood up, and there was nothing in that workspace specifically that caused that. The person, again, they could say that person, and this is probably they'd argue, and this person was obese. They're going to look at the age of the person. Anybody over 30 or over 25 is elderly when it comes to the workers' comp hearings. So if if you're again over the age of 25, everything is due to the fact that you're old. Okay, according to all these medical examiners. So they're going to say this guy was obese because he's and basically if you're not at the perfect weight level for your age and height and et cetera, then you're obese. So if you're over 25, you're old, and if you're slightly above the perfect normal weight, then you're obese. So they're going to say this guy's obese and he's old, and the injury to his knee is completely unrelated to standing up and down. That's idiopathic. It would have happened anywhere. But again, it happened because he's doing his job duties, and it fulfills that in course of an arising out of employment situation. So then you're asking, you mentioned this thing idiopathic, and the way I look at idiopathic, and I think this is the way that the courts apply this and the Industrial Commission applies this, is idiopathic a lot of times is kind of goes hand in hand with passing out. So when I hear idiopathic, I'm thinking, and this is how I encounter it, is somebody passes out, they fall down, they hit their head on the ground, and they passed out because either they had a seizure or they fainted because they didn't have enough food for the day, something of that nature, or they're doing drugs, and that's a whole other thing. So, but usually it goes hand in hand with passing out due to fainting or a seizure, and they just hit their head on the ground. Now, just going as a side, there's a lot of side things. If you pass out and have a seizure, that would be idiopathic. But if you're working in a place, like let's say you have aisles on either side with shelving, metal shelving, if you were to pass out and bonk your head on the shelving, then it's a compensable claim because the hazards of the workplace are such that your head, you're in a because you're at work and because you're near the shelving units, you bonk your head on the shelves, and therefore it's a compensable claim. So if you hit your head on the floor, not compensable claim. Shelving or table or whatever, compensable claim. So these are the reasons why you need an attorney, because they have all these weird little twists and turns of these things. But in this case, again, this is a good case because this guy actually did nothing. He didn't trip. He wasn't lifting anything. He was bending down looking at something, and then he got up and he experienced pain. So this is a good case. And this is the final case I have. And then there's always going to be cases. Case law is always happening. So this is probably not exhaustive, and there could be new cases, and it could be, something changes in the future. But this is 2008 case in another first district. It's Emmert versus Mabe. Claimant sat down in a chair to pick up a piece of litter and experienced pain in her knee when she stood up. The court upheld the allowance of the claim because the claimant was on the employer's premises on the clock and performing her duties when she was injured. So this is the case law. These are examples of this coincidental employment defense put forth by the employer where it's been rejected. So again, this person sits in a chair, gets up, experiences pain in the knee when she stands up. So, if you have, if you go to a hearing and you're not represented and they bring this up coincidental to employment, call somebody, get somebody involved so they can help you out. But be aware that the coincidental employment defense does not work. And what really kind of pisses me off about this is this is somebody I don't this is a claimant I don't represent, but this person had called up having been represented by somebody else, and unfortunately at that point in the time we couldn't get involved. It was too complicated for us to have gotten involved at that point. But what happened is he had fallen down the steps of his he was in the place of employment, and it was a 2-story place, and he was walking down the steps and he fell down the steps, and the staff hearing officer, the second level hearing officer, put this exact same coincidental employment, and their argument was he wasn't supposed to be on the second floor, and because of that, he wasn't supposed to be there, and he was just walking down the steps, and therefore there was coincidental employment. That is ridiculous. That is beyond stupid. Like, that is the worst decision. Whoever that hearing officer is, that was a terrible decision, hearing officer. And whoever the attorney was for that claimant, that was in that case, you need to write a memo. Request third level appeal, request for recon, and then when you go to court, you're gonna be doing drafting motions. But that is ridiculous and absurd. So, assuming what that person was telling me was correct, that claim should totally have been allowed, barring any other defenses that the employer could have brought up, which were legitimate, which, as far as I was aware, was not the case. But you're walking down steps and you fall in your office or your workplace, that is totally a compensable claim. Assuming you didn't pass out, because even then, you'd probably be a compensable claim because of the hazards in the employment. So really, yeah. So you fall down the steps at work, compensable claim. Don't ever let anybody say coincidental employment, and it's a terrible defense. And if that happens to you, you need to call somebody. If you want to call us and just talk about it, go ahead. If we may get involved, we may not. But this is that issue. If you see this, no, that is not a defense that an employer can use, because the courts of Ohio have rejected that defense and have not applied that defense and allowed the claim to be denied on that basis. So that said, thanks for listening to this video, and we'll have some other videos in the future. Thanks to Malek.